Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be the Los Angeles Housing Department Exposed. Well, hello everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. Now, if you are watching this broadcast live, the name of the song was I Will Survive by Gloria Gaynor. It was released in 1978. And the inside story about that song was that she recorded that song while she was recovering from a traumatic spinal injury when she had fallen on the stage during a performance. She actually wore a back brace when she was doing the recording. And of course, it showed Gaynor's survival and resilience in terms of continuing on with her career, even though that she had suffered that traumatic injury. Actually, the song, this is interesting, was featured on the B side of the album, but of course became an outrageous hit, even though it was on the B side. And for anybody too young to know what a B side of an album is, go to YouTube or go to Google and look it up. Okay, the show format. The show format is that I always open it up with a topic. And then after the topic, if you are in the Zoom meeting, I'll call on you for your questions and answers. If you're in the Zoom meeting right now, please electronically raise your hand and we'll have the best chance of taking your questions during the show. If you are watching this on YouTube, I would ask, please, if you could hit the like button and also subscribe to my channel because it really does help me. So what's the topic today? The topic is the Los Angeles Housing Department Exposed. Yes, the Los Angeles Housing Department Exposed. And that's why I kind of played that song, I Will Survive, because that's what we have to do in the hands of this governmental agency, which is attempting to destroy landlords. Now, I want to open it up with a couple of stories. This was posted as a reply on my YouTube channel, which is at evict123. And this woman posted this, and I wanted to read this to you. I put all my life savings into a property, foolishly thinking it would provide me with income in my old age. The tenant's vicious dog destroyed and chewed up my property. I had to pay her $30,000 to get out. Now, she lived there for 10 years. I never raised her rent in good faith. I am now forced to sell my property and get out of this so-called liberal city. This is the harm that our governmental agencies like the Los Angeles Housing Department is foisting upon income property owners who give such a valuable service, which is to provide housing for people. Now, the second story involves a lawsuit that we were just involved in. My client's name was Mia, and she was forced to file an eviction against her tenant. Now, the rent for this two-bedroom house in the city of Los Angeles was only $1,675. The tenant had not paid rent for 1 year. She came to our office in October of 2024. The tenant was represented by the Basta Group, and of course, they always request a jury trial. Anyway, due to the tactics of the tenant's attorney and the delays in the court system, the jury trial didn't actually commence until March 25th. There were numerous frivolous briefs filed to further the delay for the court system and to increase, of course, the attorney's fees involved. I believe that the Basta Group gets paid partly by governmental grants, which of course inures to their benefit if the case is extended. Now, my sweet client prevailed, but this certainly took a toll on her health and seriously affected her income. This property is the sole income that she relies upon. There's little chance that she will ever see the lost rent for all the years that this tenant didn't pay rent. I wish to extend My congratulations to my associate, Freddie Vasquez, who endured the barrage of legal maneuvers by this law group. The jury, consisting of many tenants, still sided with my client. Now, the Los Angeles housing function is not to protect tenants. It's to rob and rape landlords. They have no concern for the housing industry and the lives that they are impacting. Their stated goal of making rents more affordable has had just the opposite effect. Now, these are the tactics that the Los Angeles Housing Department has used. And we've talked about this before. In the city of Los Angeles and in unincorporated areas of LA County, you cannot serve a 3-day notice unless the total amount owed exceeds the fair market value. So for example, if you have a single unit, the fair market value is $1,856. If it's a one bedroom, it's $2,081. A two bedroom, $2,625. So if I had a one bedroom apartment that was going for $2,000, I would have to actually wait until the second month. So now the total rent owed would be $4,000, and that of course would be above the threshold of $2,081. Now, I had a jackass comment on my YouTube channel that, oh, the poor landlords, they only have to wait another month before kicking out tenants. Well, let me talk to you personally, Mr. Jackass. Landlords have to pay their mortgage on time. They have to pay their property taxes on time. They have to pay their fees to the Los Angeles Housing Department on time. And if they're not on time, guess what? There's penalties involved. Tremendous penalties, I might add. So you're asking us to wait 30 days, and that's what you saw as such a small inconvenience. Well, let me tell you this, Mr. Jackass. Why don't we have your employer pay you 30 days late, and let's see how you feel about that and whether you have the ability to pay your bills. Landlords have bills like anybody else. We have to take care of issues with the apartment directly. We have to pay our vendors. All this is on the shoulders of landlords, and yet the City Council of Los Angeles, instituting this, quote, fair market value, is forcing many landlords who charge less than the fair market value to wait an additional 30 days. Let's move on. As a note, any violation of the Los Angeles Rent Stabilization Ordinance constitutes a complete defense to an unlawful detainer action. It doesn't matter how trivial it is. So, for example, the city requires in Los Angeles that if you are terminating the tenancy, you're going to serve a notice to pay rent or quit, or you're going to serve a notice to perform or quit. You have to, within 3 days, upload that notice to the city. If you don't upload that notice to the city, that's a complete defense if you bring forth an unlawful detainer. So you've already waited that 30 days to get above the threshold. But if you didn't upload that city, and who knows these laws, okay? Who's even going to know that? But if you didn't upload the notice to the city, you lose their case. Now, why does the city want you to upload these notices? What do they do with them? Do they check them out? Do they find some inconsistencies and then they contact the tenant or they contact the landlord? Is that the reason? And the answer is, I've discussed this with people who work for the Los Angeles Housing Department. Do you know what they do with these uploaded notices? They do nothing. They don't look at them. They don't comment on them. So why would a city request landlords to upload notices to their department if they're not doing anything with it? Well, it's very simple. They want tenants' attorneys to review whether, in fact, the notice was posted. And if it wasn't posted with the city, you're going to lose your case. It's just a tactic by the Los Angeles Housing Department to make landlords lose their case. Let's move on. The Los Angeles Housing Department requires that certain notices dealing with tenant protections have to be posted on the property. If you don't have those notices up, You can lose your eviction case on the basis, regardless of whether you were doing it for non-payment or anything else. If you didn't have that notice posted prior to serving the notice, you lose that case. Well, how does landlords even know this? Landlords aren't served notices by the city as to what their obligations are. We have to find out ourselves. You have to check with your legal counsel. And if you make any mistake, you lose. But here, we have to inform the tenants of their rights by posting it. And if you don't post it, you lose your case. And God knows these tenants are ripping these notices down as quickly as they can so that they have a defense in an unlawful detainer action. Let's move on. In the city of Los Angeles, you have to pay yearly interest on your security deposit. If you don't pay the yearly interest on your security deposit, that's a complete defense to an unlawful detainer. I don't care whether you're going on a nuisance or you're going on non-payment of rent, it's a complete defense. If you're curious as to what interest you have to pay on a yearly basis for the city of Los Angeles for RSO properties, you can go to my website, evict123.com, click on the button called legal issues, and it will tell you year to year. If you haven't done that, do it now. But why is the city requiring landlords to pay interest on security deposits? You know, when you lease a car, you have to pay a security deposit on that, correct? Do they make you pay interest on security deposit? On what basis is the city making this law? And by the way, the interest is so low for most of these years that the amount owed to the tenant is infinitesimal. It's like $15, okay? The tenant really gains nothing by this, but yet the landlord can lose their eviction case because of the morons who run our city. And this is exposing the Los Angeles Housing Department, making landlords lose because they don't care about tenants' rights. They only care about making landlords lose their cases. Now, you might have heard in the news that the city of Los Angeles is facing a staggering budget gap of $1 billion for the 24-25 year. They claim that there's going to be big changes that are likely going to impact the lives of many Angelenos. A lot of social services are going to have to be canceled. And also people are going to have to be terminated because they're facing this $1 billion deficit. Thank you, Mayor Bass. So in the face of trying to cut down their staff and the face of trying to get rid of some of these programs, what did that city council just do last week? You know what they did? They passed a right to counsel for tenants in eviction cases. So if the tenant qualifies by being low income, they have a right to counsel. Who's going to pay for that? The city of Los Angeles. Wait a second. Didn't I just say that the city of Los Angeles is facing a $1 billion boondoggle deficit for their budget? And yet, in the face of that, when they're going to have to end social services to some degree and fire people, they're now going to foot the bill for a tenant to be able to screw their landlords by having an attorney present? This is insane. Let's move on. Recent reports of mismanagement by the City of Los Angeles Housing Department has led to a settlement with the federal government of a $38.2 million settlement. They had audits which showed poor financial accountability, making it difficult to track and determine if the programs administered by HUD, the Housing and Urban Development, are being handled properly. They have agreed, the City of Los Angeles, to pay $38.2 million to resolve these allegations, knowingly failed to meet federal accessibility requirements on funds granted by HUD. It showed, the document trail showed, provided by the Los Angeles Housing Department was so poor that it made tracking their spending impossible. Yet they took the money from the federal government, obviously squandered it like they do most of their programs, and now they're facing a budget crisis of $1 billion. Ladies and gentlemen, this is my expose that the Los Angeles Housing Department has been exposed. There is not set up to, quote, protect tenants. Their job is to make landlords go out of business. And that, ladies and gentlemen, is my topic today, the Los Angeles Housing Department exposed. We're now going to open it up to questions and answers. And we know the rules, and that is that this broadcast is for informational purposes only. It's not a substitute for legal advice. If you do want to talk to me, it's so simple. If you're in the meeting room, the Zoom meeting room, please electronically raise your hand. You can do that now. Also, if you have a specific case with my firm, this broadcast is only for general questions only. And if you are talking to me, it makes it much more enjoyable if you leave your camera on so that we can all see each other. And once again, if you are watching this on YouTube, please hit the like button and subscribe to my channel. And with that, we're going to open it up to questions and answers. Our first person will be Jean Paul. I'm going to ask you to unmute yourself.
Good afternoon, Dennis. Thank you very much for sharing this information and providing this venue. A lot of good information. Everybody's receiving the 2025 annual JCO bill, and seems to be a little misinformation going out there. I'm being told that now you have to have a 90-day notice for a single-family home in the city of Los Angeles to increase the rent 9.9% or under 10%. That's always been something that, is that true? Is that correct?
Okay, well, first of all, this is the state law. If you're raising the rent in excess of 10%, it is a 90-day notice. If you're raising the rent 10% or less, then it's a 30-day notice. That's just a state law. It's not akin to the Los Angeles Housing Department or this city.
Okay. Do we know when the effective term for this 2025 annual JCO is? Does that start from January 23rd when they voted on this, or is this a June to July?
It's going to be every year, January 1st. However, this year they're extending it till April 30th that you have to register your units. Your residential unit is subject, and I don't care what kind of a unit you have, single family home, makes no difference. In the city of Los Angeles, your residential unit, if it's not subject to the rent stabilization ordinance, then it is subject to the just cause ordinance. And this is what we've talked about in a previous show. It's just a terrible money grab by the city. So you have to register your unit. Now, many people who haven't leased their units are still getting this, which means that you have to apply for an exemption, which has to be filed yearly. Well, I just got mine for a house that is not rented, and I just got mine. So I went online, and then to fill out the exemption form, just to say that it's vacant or that it's occupied by a family member or occupied by myself, you've got to fill out this exemption form. Do you know what's part of this form? Part of this form is that you have to have it notarized. They're forcing everybody to go and pay for a notary just to tell the damn city that, hey, this property is not rented. But this is what we're faced with.
Thank you. That's incredibly frustrating.
Thank you, sir. We're going to move on to, let's move on to Jim Polina. How are you?
Doing good, Dennis. Nice to see you again.
Nice to see you. Oh, you're wearing a sports jacket. Very nice.
Yeah, I am. Thank you. I have a couple questions. One, if a landlord loses their property due to foreclosure, what happens to the lease and the new owner?
Okay, if your property is like subject to Los Angeles rent control or most rent control jurisdictions, that lease stays in effect. And unless it was not negotiated in good faith, like it's for $2 for a 10-year lease. But if it was negotiated in good faith, then that lease is there and you're subject to that lease.
And outside LA?
Excuse me?
If it's like in San Luis Obispo?
San Luis Obispo, I don't think has rent control, but I do. So I don't think that the lease survives the foreclosure. under general rules. There were some federal rules on that subject, but those rules sunsetted. In other words, they are over with right now. So I think you can serve the tenant with a notice to vacate, even if he has a lease.
I see. And regarding rent increases, notices like 30-day or 60-day notice for rent increase, does AB 1482 indicate a minimum period of time to rent increase?
Okay, well, first of all, there is no 60-day rent increase notice. There's only two. It's a 30-day notice or a 90-day notice. As I told our first caller, if the rent is 10% or less, that you're increasing it by, then it's a 30-day notice. If you're increasing it more than 10%, it's a 90-day notice. And
Okay.
under 1482, the Tenant Protection Act, right now it's 8.9%, and you are allowed to increase the rent twice as long as in any 1 year period, as long as it doesn't exceed 8.9%.
Very good. Thank you, Dennis.
Thank you, sir. We are moving on to Celeste. How are you?
Hi, I'm good, thank you. How are you?
I am fine.
So I have a quick question. I have a single family dwelling in I guess it's considered Ventura County. And I have we're just getting in May, the 1 year lease will end. I did not check the box to automatically go month to month. I was considering it, but I'm not going to do it. In the meantime, in the last 2 months that the tenant is there, he is refusing that I have access to show the house to potential renters on the weekend because he claims this is not normal business hours. I'm a school nurse. I work Monday through Friday and quite a distance from the house. And I'm just wondering if he has a right to refuse my entry.
Okay, well, first of all, thank you for your service as being a school nurse. How important is that function?
Thank
Uh,
you.
but normal business hours are Monday through Friday, 9 to 5. So you're going to need to get some sort of an agent to go during the regular week to show it. I know it's not convenient because most applicants want to do it on the weekends, but you're kind of stuck with that.
So even though there's no mention of the hours in the lease, it just says 24-hour notice
Well,
necessary?
unfortunately, you're subject to Civil Code Section 1954, which talks about normal business hours.
Oh, gosh. Okay, that's a bummer. Can I ask one other quick question?
Of course.
This tenant has a couple e-bikes, and from your month-to-month lease, I realize that there's certain things that have to be in place in order for somebody to have an e-bike. And I asked him to please stop charging it in the garage. I'm afraid of a fire hazard, obviously, and my insurance company already said that they would not cover any fire due to his e-bike, so I could potentially lose my entire home. Is there any legal standing that I have in that regard?
Well, I mean, you can bring forth an eviction if he's violating the terms of the lease or violating any state law. But again, the lease is almost over. When does it
Right.
expire?
May 31st.
Yeah, there's really nothing
Not
else.
even,
Just
okay.
just hang tight. Anyway, thank you very much. We are moving on to Sonia. How are you, Sonia?
Yes, Dennis.
Yes.
Hi, thank you. Sorry, I can't, my camera isn't working right now. But I also had a question regarding the notice for the JSO. I guess they're calling it rental registry now.
Yeah.
That. So for a single family home, my question is as far as it being rented, the information that they ask, I'm looking at the printed form as far as the unit number, number of bedrooms, when they moved out, and everything. As far I think the last rent received or the last rent increase. My question: number of bedroom. We have a single family home, but what if on tax records it's two, and there's a third bedroom that's not on tax record, but it's been used and it was purchased that way.
Does
So
that third bedroom have a closet?
yes, it does.
Okay, so was it a bootleg unit? In other words, did somebody kind of created a closet to make it into a bedroom?
No, no, no. It was. It's much bigger than a bedroom. It looked like it was like a larger room. That's how it was when it was purchased.
Well,
That would it was like a larger patio, I guess, but it has the AC. It's got the closet. It's pretty. It's just
okay.
on tax record. It
Are
doesn't
you
show.
asking how to fill the form out?
Yeah, so do we put 2 bedrooms or we put 3 bedrooms?
I'd probably put 3 bedrooms because that's what you have. If it's a room that has a closet, then that's considered a bedroom.
Okay, that's how it was rented out to be
Yep.
in regards to that. And then and then the question is like if during that year, if they leave and we get a new tenant and maybe we increase the rent, do we have to update and refill this form out
I think you only fill it out once per year. I don't think you have to fill it out again. No.
during the year? Okay.
Yep.
All right. Okay, thank you so much.
All right. You take care. Thank you for the question. How's my New York friend Janice doing?
Well, I'm doing fine. How are you, Dennis?
Good. How's the weather today?
48 and rainy, the longest winter in the past 10 years.
Okay. Well, don't feel bad. It's about 75 here in beautiful weather.
Yeah, I'm sure. But I'm not sure that makes up for the real estate laws in LA County.
Well, you don't have
Question.
great laws in your in your
No, we
jurisdiction.
don't. They're moving up on California, but I don't think every once in a while there's a victory here. Anyway, I'm on this e-bike question. Am I required to rent to people who have e-bikes, or could I just put that in the lease, no e-bikes?
Um, I'm not actually sure on the answer to that, whether they're in California, whether that's a requirement or not. I'd have to look that up and give you an opinion next week on that. I know they have certain rules with regard to e-bikes, but can you just ban an e-bike? My guess is probably no, but I'll take a look at that and tell you next week.
Yeah, because insurance companies really don't like them. And in my case, it's a choice between putting a charging, rewiring the garage to make
Exactly.
it safe, or the house, which definitely would not want. But okay, I'll look forward to next week. Thanks.
Thanks, Janice. Okay, moving along to Doug M. How are you?
Doing well, Dennis. A quick question. Where did you get that license plate next to you?
You know, my sister-in-law, Sharon, got that for me. She knows, of course, I'm the biggest Laker fan. And those are, if you can't figure that out, it's cut up license
Yeah.
plates from different states. I see Georgia, Michigan. I can't pick them all out, Louisiana. And so they put that together. And she bought that for me, and I really like that piece.
Yeah.
And if you guys have noticed that every show I'm putting another bit of Laker memorabilia on my side there. So always take a look for that.
Gotcha. Gotcha. Okay, cool. Yeah, so my question is, has anything changed for, I guess, the laws on rent gouging that are currently in place right now? The reason I ask is because I guess there are certain rental management companies that are giving different answers as far as whether or not one can increase rent or increase the rent on newly vacant units. They're saying you can't go
Okay.
past 10%.
Yeah, I know.
And
And then they're saying 150% of
right.
me the average median value for that unit, the fair market value. I think it's a
Mhm.
bunch of hogwash. You're allowed to, if a tenant vacates your unit, you can charge whatever you want for any tenant coming in. This issue that quote, first of all, it's going to be over as of July anyway. And if you're going to rent out the unit, you're almost there anyway, since we're in April. But you can raise the rent to whatever you like. Now, this is for a vacant unit. And the reason I'm saying that is based on the Costa-Hawkins Rental Act. That says specifically, notwithstanding any other law, if it's a vacant unit, the landlord can set whatever rent he wants. That's what it says in that law. So I don't care about, quote, the governor's state of emergency declaring in LA County, which extends through July because of rent gouging. You have the right to raise the rent because it's a vacant unit, okay?
Mhm.
And you're, quote, not raising the rent. You can make the argument you're just setting the rent. You're not raising the rent. There's no one there.
Mhm.
So I think it's a total overreach, but the law is clear, and I don't think anybody could get into trouble based on the fact that the law is clear on that. So if you've got a vacant unit, then I would rent it for whatever the market is. Now, with regard to existing tenants, let's say in a single family home, which we've talked about many times, that you're not subject to rent limitations. For an existing tenant in LA County, I would not raise that rent because it could be considered rent gouging.
Right.
It just makes it more dicey for an existing tenant than for a vacant. However, in both cases, the law is clear. I can set the rent for whatever I want on a single family home. And that starts with notwithstanding any other law. So I don't really care about a state of emergency. So raise the rent and be proud.
Gotcha. And I have a question on a tenant that is moving out, and unfortunately, the way this is from a family member, but unfortunately, they rented it out to a tenant that they didn't ask a deposit for. So there is no deposit, and it was originally two people, a couple, and now they ended up having four kids, and they were growing up, and now they're moving out, and there's a lot of damage. So, what does one need? Is it because I don't even think they have their social security numbers. All they have is like pictures of IDs, as proof, of who they are. What does one need in order to go to small claims, in order to have a good case and be able to get?
Well, you
Mhm.
don't need to have a social security number to file a small claims court. You just need to know their names. The
Okay.
problem is that you need to know where to serve them. And if
Okay.
they've already vacated and they didn't give you a forwarding address,
We have an address. We have an address.
so
Yeah.
go to small claims court,
Yeah.
and come with your proof as to your estimates and pictures,
Hmm.
and then you'll obtain a judgment, hopefully. When you have that judgment, if you give it to a collection service, such my firm, of course, deals with hundreds of thousands of dollars in collections per month, we can immediately tell you what your tenant's social security number is, generally where they work, and of course where they bank, assuming they are working and assuming they do have a bank account. So we at our firm, of course, have the best collection databases to ferret out this information. So all you need to do, though, is get a judgment. Once you get a judgment, we can take it over from there.
Okay. Excellent. Yeah, that was it. Thank you very much.
Thank you, Doug. And we are moving on to Jonathan Kennedy. How are you, sir?
I'm well, Dennis. Thank you. I have a couple of questions about the rental leasing requirements form that you have on your website. Um, the first question is you put that a credit score of 700 or higher is required, but individual circumstances will be considered.
Correct.
Uh, in my requirements, I have I have a similar, I have a number also for the credit score. But it seems like you're sort of asking for a discrimination complaint if you say individual circumstances will be considered.
No, I
I
don't
don't
think
know.
so. The fact that you can have a little bit of wiggle room, so it's not just 700, because you could get into an issue where that could be considered discrimination. So potentially, so I would definitely leave that in there. And I think it does just, first of all, you're not allowed to take an application fee under the new rule unless you hand them these leasing requirements so that the tenant knows that, hey, I'm going to pay an application fee, but before I even turn in my credit, I know I'm not going to be accepted. So that's why the legislature made this requirement that you have to submit this form to the tenant. So, but I do like the way I structured it.
But you don't think that, like, you deny some tenant who, had a 675, and then another tenant comes along with a 675, but you decide that their circumstances,
Right, but then it would have
um,
to be on their circumstances. I mean, maybe
yeah,
the
but then
guy
the
had a
first
bunch of
tenant comes,
hospital bills, for example,
right.
and that caused his credit to go down, but he's been a gainfully employed person for the last 20 years and works for the post office.
Yeah, I know, but then the tenant who is just a deadbeat comes along and they say, "Well, you denied me and my credit score is 675." So, you know.
Well, first of all,
But
how is that tenant going to know the other tenant's
yeah,
information? So that's
no,
the
I
first
agree.
thing. So as a practical matter, that's not going to happen. However,
Can't fair housing get all of your records if somebody files a complaint? Can't
but how would
they
he
come
file a
in and
complaint without knowledge? He'd have to
okay.
know that, hey, I allowed another tenant to come in at 675, but I didn't go you. How is that person even going to be able to make that claim?
Well, I mean, it could be in an apartment building and they live next to each other, but yeah, I get it. It's unlikely. And my other question is
Right,
about
before you go
the
on, Jonathan, with the other
uh-huh.
question, this is a
Yeah,
form. And
yeah,
it's a free form. And there's
yeah.
something, a concept called whiteout. If you don't like
Oh,
that
yeah.
word, just white it out and use it the way. But for my purposes and my recommendation is I would leave that in there. But go ahead with your
Well,
second.
Dennis, I mean, the purpose of my question about that is because I like the way your form is, but I'm just afraid that, it's going to be discriminatory because it's subjective. That's all.
Right. But as I stated, it's a form. If you don't like it, take it out. But
Yeah, I
again,
get it.
no one is going to be able to figure out who you rented to at what their credit score is. So
Okay. All right. And then under the income requirements, your form has a pretty standard requirement of gross monthly income must be at least three times the rent. Do you do you think that a landlord should consider or maybe could consider some other sort of scheme for an income requirement, maybe the amount of the rent plus $1,000 per adult, $500 per kid? I mean, I find that maybe a retired couple, they both have Social Security, they could pay the rent, but they don't have three times the amount of the rent. And I'd like to accept them.
feel free.
Well, I know,
It's your
but I mean,
property. This is America, and you should be able to do with what you want. The issue is that I put that in there because, quite frankly, and I've said this on other broadcasts, that if you get yourself a bad tenant and you have to evict that tenant, you're losing a minimum of 6 months worth of income plus the damage to your unit. So, as a person trying to advise landlords on proper ways to run their buildings, I think that's mandatory that they make at least three times. But that doesn't prevent you from taking a chance on a nice older couple that's gaining Social Security. And by the way, I have
okay.
Social Security, so I don't know
Right,
whether you should write to
exactly.
me or not.
And I almost do. Um, I just I everybody says three times the amount of the rent or two and a half times the amount of the rent, or like in Colorado, it's two times the amount of the rent by law. And I just kind of wonder if, people find other schemes for their income requirements.
Jonathan,
So
knock yourself out. And with that, we're going to move on to, let's move on to Daniela Moskovitz. How are you?
There we go. Hi, thanks, Dennis. Um, Los Angeles RSO multifamily. I'm preparing a security deposit refund form for a problem tenant who recently vacated. No matter what I do, it's going to be challenged. My question to you is, as I'd like to set up an appointment with one of your attorneys to review this security deposit form and to prepare, something to have a game plan in when this tenant challenges me, because no matter what happens, there's going to be a challenge.
We
Do
have
you
no
do that?
problem setting up an appointment to have you come in. We want to take a look at all of your receipts and give you some issues on how to fill out that security deposit itemization form. I mean, most landlords don't need the services, but if you're sure that it's going to be litigated, then yeah, I think that's a good idea. All you got to do is call the office and we'll set up an appointment for you.
I've tried, thank you, and I've tried to call the office and I immediately get into the attorney hotline. Is there another in, let's say in Burbank, is there another phone number that I can call and
You
get
just
to the
hit, you could hit
receptionist?
0 and get to the operator and say you just want an appointment.
Okay, I can do just 0 and
Yeah,
get that. Okay, cool. Thank you, Dennis.
thank you. Moving along to Richard Malley. How are you, sir?
Dennis, thank you very much for there we go for calling out on me. Had a couple of questions on a tenant that I rented with no parking, and I've got a separate parking agreement. Could I raise the parking more than once a year? I'm assuming I can, right?
Parking is considered a commercial lease, and you have the right to raise it as much as you like, whenever you like.
As often as I like. I thought so. And on not the parking agreements, but on a commercial lease, do you have on your website commercial leases
And the
for
answer is
commercial tenants?
no. I do have a parking agreement on my
Hmm.
website, but I don't have a commercial lease.
Got it. Are you thinking about putting one sometime in the
No, I mean
future?
all the realty companies have
Do
their
they?
forms, and they're really good. The
Okay.
standard industrial lease.
All right. Just on last week, you'd mentioned something. I made a note. If you can just clarify, I guess I made a note that you can't discriminate on age, obviously, of like a child that's on the application as one of the occupants or multiple children. Um, can we still base the rent on the number of occupants that are applying for the rental?
You
And if
can,
those occupants are
but
children,
that's not a class. So obviously, an apartment that has two people versus an apartment that has five people is going to be much more wear and tear. You're going to be spending more for the water since the landlord generally pays for the water.
right,
But as long as you're advertising that the rent is, let's say $2,000 for two people, and anything after that, it's another $100.
got it. And those people, children count as people,
Children are people.
right? I
You can ask
get
my
that question.
children.
Right, I get asked that question often, but they're children. They're
Where,
people.
and I meant to talk about this on the last show.
Yeah.
For example, in terms of, and you can do this with this example, either with children or with somebody with a disability. Let's pretend you have an apartment that's on the second floor and there is no elevator. And a person comes to you with severe paralysis. They can't really walk well. They're either in a cane or maybe they're in a wheelchair. And they want to lease that apartment. And your position is, look, I am so sorry. We don't have an elevator. There's really no way for you to get up the stairs unless you plan on crawling up every time. If you chose not to lease the property to them, then you're guilty of discrimination based on a handicap. So it doesn't matter that it's totally illogical that that person is not going to be able to get to the unit or will have a lot of difficulty with a cane. And you're thinking, well, gee, the guy's going to fall down and hurt himself, and then I'm going to get sued. You can't do that. You have to lease the premises to them. The same thing is true with a second floor. With children, you're going to say, look, maybe the child is going to jump off and hurt themselves. I don't mind leasing the bottom floor, but I'm not going to lease the top floor, but I don't have a bottom floor. You can't make that determination. The parent is responsible for their children. I know that's a weird concept, but the parent is responsible for their children. If your building was built to code and they want to take that second floor or they want to take the building that has a pool, then that's their responsibility. So that's one of the things I meant to say in our last broadcast. Anyway, thank you very much, Richard. We are moving on to our friend in Long Beach, Austin. How are you?
Hey, Dennis, pretty good. Thank you for another edition of Landlord Tenant Talk Radio. My question deals with Section 8. Your strategy for all of us has always been only offer month-to-month leases. Makes all the sense in the world because Section 8 doesn't accept month-to-month. However, I've been hearing that landlords are being prosecuted for not offering lease terms in accordance with their local housing authority. Is there a law that says if you do not offer a one-year contract, then you can be prosecuted because you're singling out a certain class of people, such as Section 8, that only have year-long leases?
Well, I don't know of any law, and you're not singling out Section 8 because, as I said in every broadcast, you are only renting month to month for all applicants. It's not just Section 8, all applicants. And there's reasons for doing that. For example, if you're under statewide rent control, you don't need cause to evict if the tenant's been there less than 1 year. If you're under the JCO for the city of Los Angeles, the just cause ordinance, you don't need cause to evict if the tenant's been there for less than 6 months. So based on those statutes, I want to rent only month to month. I don't see that as any kind of a discriminatory practice, but it also has the benefit of not allowing you, of not forcing you to take a Section 8 tenant.
Sure. Okay. One other quick question. You mentioned last time during last week's show, what's the benefit of still being able to live in a house and rent it? I can think of one benefit, and that is to be able to refinance at an owner-occupied loan rate, which is much better than an investor loan rate. My question is, if you do that situation and you have, tenants living there, you still live at the property on paper, but let's say you're physically living at some other place. If you write the leases accordingly and you rent them out per room, the east and west bedroom of a 2-bed, 1-bath, and let's say there's a non-payment of rent situation that comes up, can the landlord still prevail, or is it going to get really muddy in that situation?
It does get muddy. We do those cases all the time. However, I don't think it's a good business practice to rent out rooms. I know in the city of Los Angeles, it's considered a boarding house. It might be considered an illegal tenancy because you don't have a boarding license, even if you are, quote, claiming that it's also occupied by the owner. If you have one tenant and you're living there, that's one thing, because that's considered a boarder, and then you don't have any problems in terms of evicting the tenant, as I've told Harold Rhodes on numerous occasions. But I don't really recommend renting out rooms, but we have done it where I'm doing a case right now where we're doing an eviction against one of the 3 tenants, and when the sheriff comes to do the eviction, we're just going to put that one tenant out, change the locks, and give the keys to the remaining tenants. However, nothing prevents those remaining tenants opening up the door and allowing that evicted tenant to come back in. So it does become very messy, and I'm just not a big fan of that. I understand economically you make a bunch more money when you rent out rooms than if you rent it out to a family, but I just don't think it's a good business practice. It's hard enough to get along with your own family, right?
Yeah.
Getting along with strangers is a whole nother story.
Got it. Thank you.
Thank you. We are moving on to somebody whose name I just mentioned, Harold Rhodes. How are you?
You there?
I am.
This is the highlight of the week is Dennis Block, especially with the Lakers winning and being in 3rd place. Okay, you were just talking about my situation that I have a tenant, so I raised the rent. I put it on his door. Usually every year I just raise the rent and talk it to him, and he gets upset and all this. So this time I left it on the door. He didn't yell and scream, but then he sent me this. Here's the text. He goes, "I'm going to go to a lawyer about this," and then mildew coming through the walls. His bathroom, I've cleaned it up like 4 or 5 times since he's lived here, and he's made an agreement to clean his bathroom, but I don't press him on it because he's just a hothead. So I went in there and I just cleaned it like there's no anything. And now I want to have a piece of paper for him to sign saying there's no mold in this bathroom, because I never did it I never did a walk-in when he first moved in. Is there any way I can come up with a paper that says?
Well, I don't think your tenant's going to want to sign anything. The bottom line is mildew present because he's not ventilating the room?
No, well, mildew, yes, in a sense that sometimes his window is shut, but there is a vent, but it doesn't work. There's no automatic vent. But
okay, so then this is what you need to do, Harold, to prevent this problem. It's pretty simple.
Yeah.
Construct a vent with a fan that when you turn the lights on, then the fan comes on. He doesn't have an option. This way, that room will always be aired out, and you're not going to get a mildew problem. But mildew is not mold. Mold is a whole different story. But the tenants see mildew and they scream mold, and they're going to the hospital in the emergency room, based on the silliness of seeing some mold. So I would definitely make that vent work so that when you turn the light on, the vent comes on, your problem's solved.
But just real quick, he has never cleaned that bathroom is what it is. compiles and compiles, and it's just I don't want to press him because, like you said, you try to get somebody out, you're minus 20 grand. You know what I mean?
Yeah, well, it is what it is, but
Good advice.
yeah, tell them to clean it up. I'm moving on, Harold. Let's move on to Sam. How are you?
Oh, okay, there we go. Um, Thank you, Dennis. What happened? Okay, here we go. Video. Um, Question: how are small mom and pop landlords to comply with some was it a state requirement, to report positive rental payments to the three credit bureaus? How can somebody who has just one rental, say a single family home they're just renting out, or a couple of them, is there a threshold where you say is it five or more units you have to start reporting these things? And how can it's a very onerous thing.
Okay, well, it's not onerous at all because it only applies to units that are over 15 units on a particular piece of property. So unless you have a 16-unit building, it doesn't apply to you. But if it does, then you have to offer the tenant every year and send them a contract. I've got it on my website. And it's also contained in my rental agreement where they're going to request that you do report positive rent payments. You can charge them for every month that you do that up to $10 of the cost. But again, I don't know if it's going to apply to your property, Sam, unless you have 16 or more units.
Yeah, it's just one. Okay, thank you. Thank you.
All right. And we are moving on to John Cohen. How are you?
Oh, thanks, Dennis. Can you hear me?
I can.
Okay. I have a RSO property, 6 unit in wonderful Pacoima that I've owned for many years. And anyway, I have a tenant. It's been very difficult for 15 years or whatnot. And about 10 days ago, I getting calls from other tenants that they've left. There's a barking dog. They leave it there, etc. And I'm trying to figure out what to do. So I post a notice about 8 days ago that I'm 24-hour notice that I'm going to enter, etc. Check it out. So within hours, I get calls from them screaming at me, no, we have not vacated, we have not abandoned, da 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 da. So, and then I'd gone to a locksmith to make an appointment for the next day, would have been last Saturday after the 24 hours. So, anyway, based upon the phone call and these very difficult people, I canceled the locksmith, etc. I did make an appointment. I met with the people there last Saturday. There's no beds, there's no couches, but there's just belongings and whatnot. And the problem is he's not legal. The husband, he's waiting for his immigration papers, and he's insisting that his niece move in and take possession that I rented her, etc. So I have not agreed to that. I have 3 other people that want to rent it. It's it's $800 a month.
Let me stop you here, John. First of all, does the tenant owe you rent?
Oh yeah.
Okay.
Oh yeah. But I haven't.
I always ask that question.
Oh yeah. They owe me rent, but
okay, so
I don't
if
want.
they owe you rent, they're claiming that they're not moved. So this is simple. We need to serve a 3-day notice to pay the rent and proceed forward with an eviction. You're not going to allow, quote, his niece to move in because that's not how you lease out your property. You lease out your property by you advertising for applicants. And when you get a proper applicant, then you do that. So, and also, of course, you want to raise the rent after they're gone.
Right. But the thing is, I do an eviction and then I'm looking at Basta, and they can move her in anyway, and then I'm looking at 6 months to a year, etc.
Okay.
So
then just live with the problem, allow the person not to pay rent. In fact, you might as well just deed them the property if you're afraid to take action because you might have a jury trial on your hand. I mean, it's insane. You've got tenants that are not paying you rent. What else can you do other than start?
They pay me sporadically. They owe me rent. You asked, do they owe you rent? But they pay sporadically. So
All right, well, then live with the situation and because you're in fear of taking legal action. You've got to get them out. You'll probably be able to raise the rent significantly, I would hope. And on that basis, this was what you should do to save yourself and your investment.
Well, I'm going to go with your guidelines that you have on your website and say these are the guidelines, because I have three other people that have contacted me that want it. But the niece may be the most qualified. I have no idea. But if they move her in, isn't it trespassing?
If they move her in, then that would be a violation of the contract because there's an unauthorized person there. They're probably not even living there, right? Are they actually
Oh,
staying?
no, they say they're not sleeping there. There's no beds. They have three kids. Originally, there was no children. Now there's three.
Hey, John, this is simple. We need to serve a 3-day notice and proceed forward with an eviction. And with that, we're going to move on to, let's see. Let's move on to somebody I think really wants to talk to me. I see iPhone. I think that person was asking me a question. Are you there? I see two iPhones. I'm not sure which one. So if you're an iPhone, unmute yourself. There you go.
Hi. Yes, Dennis, I have a question that the report to the credit bureau, I have a triplex in Costa Mesa and 3 houses for rent. Some of them are on LLC. So do I have to report to the
Absolutely
credit bureau?
not. As I said to the other person, it's only for those landlords that have more than 15 units on one piece of property. And
Got it.
unless you're a corporation or a REIT, okay?
But I have an LLC.
An LLC is not
Only
a corporation. An LLC is not a
the
real
only
estate
one on that
investment
LLC.
trust. All right, anyway, thank you very much. We're going to see if we can
Got
get
it.
to.
One more. Can I have
Okay,
can I
you're
have one more?
breaking up, darling, so we're going to move on to,
Yeah.
let's see.
Can
We're going to move on to Margaret O'Brien. And please unmute yourself.
Okay. I read not too long ago that we have landlords have to allow tenants to put their bicycles into the unit. Is that true?
Yes, there is some law. In fact, I have it in, if you read my contract, that they do have to allow the bicycles, electronic or electric bicycles, or even regular bicycles, they can be stored inside the unit.
Okay, well, and then the other thing is, I just read about that either the supervisors or the city council want to require landlords in the future to provide refrigerators. Have you heard that yet?
I haven't heard that. It wouldn't surprise me. Sure, let's just pass laws that financially impact landlords because really, who cares about landlords? No, but I haven't heard that, but nothing surprises me now.
Me
Anyway,
neither.
Margaret, thank you very much. We're moving on to Veta. How are you? Veta? Are you there? Unmute yourself, young lady. Last chance. Okay, I'm going to move on to Amir. How are you?
Hi, Dennis. Thank you for taking time and doing this. My question is, I have a tenant. She didn't pay 3 months. April is 3 months. We bought a property last year, and it's not even a year we bought it. And the stubble, they gave it to us. It's only one person living there. Now I found out she rent the living room to someone else. So just because you got to demo it, you got to go affordable housing, you got to do LS Act. I was trying to just uh, work out something with her, but at this point, she stopped paying rent, and it's been 3 months. And today, she sent us a rent for April. So what should I do? Should I return it?
Wait, did you
Check?
say she owes you 3 months rent? Did I miss that?
Yeah, she owes me February, March, and April, but I received the check for April.
I would return the check. What city is this?
Los Angeles.
Okay, return the check, and we should immediately start a case based on two issues. Number one, non-payment of rent, and number two, that they're violating. I presume she signed a contract, correct?
We already started the eviction with your
Okay.
co-
All right,
with
so then
your
we're probably doing it on non-payment rent. I don't want to talk about a
yeah.
specific case, but
Okay.
again, we could go on both issues, unauthorized occupants or non-payment of rent, or we could pick and choose. Usually in that situation, we would do both.
So I'm gonna email. I'm gonna mail the checks back to her, And
Oh,
should I do the
yeah,
explanation to it?
since we're involved in a specific case, call me at the office because it might be critical, this question. Okay,
Got
and I
it.
want to take a look at it. Anyway, thank you very much. We're going to end the show with Veta. Are you there, young lady? Can you unmute yourself? Come on, Veta.
Okay,
There
got
you
it.
go.
Thank you. Sorry about
You,
that. Hi,
you got
Dennis.
it.
Hi, everybody. I was so regarding the security deposit and the interest, and if you're in the middle of an eviction, so send them $20 or what?
Well, unfortunately, you're not supposed to serve a 3-day notice unless you've complied with the statute. Otherwise, it's a defense. So serving it now doesn't necessarily help. But again, we're only talking about RSO properties in the city of Los Angeles. Is that where your property is?
Yes.
Okay, yeah. I mean, most of the time it doesn't come up, but if you got some sharp attorneys on the other side, they've been raising this issue. We do have a way, a brief that we've prepared that might be successful in terms of defeating this. But again, if you haven't done so and your property is in the city of Los Angeles under rent stabilization ordinance, you want to make sure that you do send that interest on a yearly basis. And with that, I'm going to say thank you very much for joining us this week. As you know, we're going to do this every Saturday at 3 p.m. Again, if you are in the YouTube meeting, please, I would ask you to like the show and also subscribe to the channel. Everybody, have a great weekend. Thank you so much.